Okay, so I missed the introduction there. So we want to be able to dig deeper into the idea of judicial powers, mainly because of the Boilermakers case, which raises the question of what exactly are judicial powers. Because if we do not know what judicial powers really means, then we will not be able to tell when the vesting of certain powers upon non-Chapter 3 courts may actually already be a breach of the Australian Commonwealth Constitution. So following the Boilermakers case, as I said, the High Court has been very clear that it will not tolerate the vesting of judicial powers on non-Chapter 3 courts, and at the same time, it will not allow the vesting of non-judicial powers on Chapter 3 courts. So, and that's the reason why we are examining further the concept of judicial powers in tonight's tutorial. Now, in terms of the key outcomes, after studying this topic, you should be able to identify, distinguish, and explain judicial and non-judicial powers. Should also be able to explain the separation of Commonwealth judicial and non-judicial powers, and cite and discuss key judicial decisions that elaborate on the notions of judicial and non-judicial powers and the separation of Commonwealth judicial and non-judicial powers. But before we start looking at the legal problems at tonight's tutorial, would there be any questions or anything that any of you might want to raise? Comments, questions so far before we proceed with tonight's tutorial?
So it's Monique.
Monique, yes.
You answered a question on Moodle regarding quasi-judicial.
Yes.
And clarified there that you need to determine whether, or you need to look at whether there's new legal relations being formed or made as opposed to existing ones. Can you please elaborate on that? I just don't quite understand what kinds of new legal relations you might be referring to.
Yes.
Thanks.
So we begin with the idea that as far as judicial power is concerned, judges make an adjudication on the basis of existing legal rights and obligations. So the purpose of an adjudication by the courts is actually to determine what the legal rights and liabilities or obligations are of parties in a case based on what exists. So, for example, if there is a contractual dispute, the role of courts would be to determine what exactly are the rights and liabilities of the parties on the basis of an existing contract. You can contrast this with legislative powers and executive powers. In relation to legislative powers, for example, when a law is passed by the Commonwealth Parliament, for example, what it does typically is actually to create new legal rights or new obligations. So the new legal right might be in relation to certain benefits that we get. It could be in terms of rights in the course of a civil proceeding. It could be in terms of rights in the course of a criminal proceeding. So what the legislature does then is to create new legal rights. It in fact changes legal relations between the parties. So, for example, if the law previously had been, in a particular manner, it is possible for the legislature to change the legal relation. So, for example, it might be that in relation to a marital dispute, it could have been that prior to a change in the law, it may be that persons with the same sex would mean that they will not be able to benefit from the marital relations as determined by the appropriate legislation. But given a change in the law, because the legislature, for example, passes certain laws, then it's possible that new legal relations will be created. And that's the reason why, as far as the same-sex marriage legislation is concerned, it is a hot topic. There can also be new legal relations in terms, for example, about child custody involving marital disputes. So in the past, the question had been who had better rights over over custody over the child. But that has now been changed so that the bigger question is, who is in a better, what exactly are the rights of children. So the focus is not on the parents, the rights of parents, but really on the focus of children. So if you will notice, there has been a change in legal relations and rights and liabilities. And from the viewpoint of the executive as well, the other difference is that the executive, for example, when it comes to a proceeding before an administrative body such as Centrelink or let's say Medicare, it is possible that the Medicare or Centrelink, when it makes a determination about the rights of an individual, doesn't really focus on the existing rights of an individual. It can actually create new rights and even new liabilities on the part of an individual on the basis of the statutory framework that it allows the original decision maker to take into account the circumstances of an applicant. It will also allow the administrative decision maker to examine public policy. So what that means, therefore, is that if there is a power that is vested on a tribunal, and I'm using the word tribunal in a very broad sense because the basic question really is, at the end of the day, is that tribunal a Chapter 3 court or not? Or is it exercising judicial powers? So I'm using the word tribunal in a bigger sense. The bigger question then, for example, is that assuming that there is a law that has been passed which vests in a tribunal the power, for example, to change legal relations between the parties, then that would suggest that that tribunal is exercising non-judicial powers. Now, if that is the case, then we begin to ask, assuming that that power has been vested on a tribunal that has been constituted as a Chapter 3 court, in accordance with Chapter 3 of the Australian Commonwealth Constitution, then that would then go against the proscription in the Boilermakers case. Or if there is a law, for example, which enables a particular tribunal to determine the legal rights between parties, such as, for example, questions about tenancy agreements or contracts, but that particular tribunal, for example, has not been constituted as a Chapter 3 court. And it is apparent that because that tribunal is making a determination on the basis of the existing rights and liabilities of the parties, it is therefore exercising judicial power. Again, that would go against the proscription of the Boilermakers case. So that's the reason why it is crucial for us to know whether or not a particular tribunal attempts to exercise judicial powers. And relating to your question, we make a distinction between whether or not the determination or adjudication made by a tribunal relates to the existing rights and liabilities of the parties, or whether or not the tribunal actually is in a position to create new legal relations. Was that sufficient, Monique? Okay, thank you. Other questions? None? Okay, so we could proceed. So let's begin with discussion question 1. Do I have a volunteer who would like to read discussion question 1 for us? Can I get a volunteer just to read discussion question 1?
Okay. Jim Freeman was arrested after images of child pornography were found in his computer that was seized by the police. His computer had been seized and searched on the basis of a search warrant issued by the judge of the Federal Court of Australia under the new Security Measures Act Commonwealth. He challenged the constitutionality of the Act, arguing that in issuing the search warrant without giving him a right to hearing, the judge breached the rules of natural justice and exercised a non-judicial power that was proscribed in Boilermakers' rule on the constitutionality of the Act.
Thank you, Ren. What do you suppose, before we rule on the constitutionality of the Act, and for the purpose of trying to practice how to answer legal-based problems, what do you suppose is the legal issue that has been raised by this legal problem? What exactly is the legal issue?
I think it might be best described, Manjo, as a judge exercising non-judicial power.
Okay, so to Jason, the legal issue is whether or not whether the judge is exercising non-judicial powers.
Hi, Manjo. I'd probably say the legal issue is whether the rule of law would make it unconstitutional.
Okay, so whether there is a violation of the rule of law. Okay. Yes, others?
Whether there's non-judicial powers being vested in a Chapter 3 court violates the separation of powers.
So whether non-judicial powers are being vested in a Chapter 3 court. Very good. Anything else? Okay, so as a matter of practice, why is it crucial again to identify the legal issue in the first place? So why don't we begin by answering, providing an answer to the question of rule of the constitutionality of the Act? Why do we need to identify the legal issue in the first place?
Because it might be legal in the first place and you'd be wasting your time trying to answer it.
Mm-hmm. Okay. Very
If
good.
you can't identify the legal issue, you can't identify the relevant rules.
That's right. Who said that?
Jamie.
Jamie, can you explain that further for us? If you could, if it's all right.
Yeah. By identifying the legal issue, you're identifying what could possibly make the act or the action unconstitutional or invalid. And if you haven't identified that, then you can't possibly identify the rules that apply to that principle to know whether it's unconstitutional or invalid.
Very good. Thank you. Thank you. That was very good. Okay. So as pointed out correctly by Jamie, the legal rules enable you to kind of, in terms of I think Jamie even may have explained it better than I will. But what Jamie was actually saying, that being able to identify the legal rules enables you to then identify the legal identify the legal issue enables you to identify the legal rules that will then enable you to answer the question of whether or not a particular law that has been passed is constitutional or not. So you can only answer the question about the constitutionality of the act by knowing what the legal rules are that would inform that particular question. But knowing what the legal rules are actually requires identifying what the legal issue is, because the legal issue then leads you to the rules. Okay, so very good. So I think, so we have two ways of at least identifying the legal issue, and either would actually be correct. One is whether the Chapter 3 judge is exercising non-judicial powers, because if he is, or he or she is, then that can potentially be a violation of the Boilermaker's rule. But secondly, the other question, or the corollary to that, is the question of whether or not non-judicial powers are being vested in a Chapter 3 court itself. Now, that is a different question to whether or not the non-judicial powers are being vested on the judge as opposed to the Chapter 3 court itself. So those are two different things. We raise that point because, as Leonie says in the chat, does the persona designator rule apply? Okay, so we're going to go back to the persona designator rule in a short while. Now, having identified the legal issue, can somebody attempt to tell us what the legal rules might be that inform on the legal issue? Volunteers? What are the rules?
Per the Boilermaker's case, non-judicial powers cannot validly be vested in Chapter 3 courts, and non-Chapter 3 courts cannot be vested with judicial powers.
Very good. Okay. Now, is there another rule that acts as an exception to the Boilermaker's case?
Persona designator rule.
Thank you, Marie. Can somebody try to explain to us what the persona designator rule is about?
Well, a judge can be a judge of a court, but if he's appointed or consents to being appointed to another form of tribunal, if he does so within his own personal right rather than within the court's jurisdiction, then that represents a persona designata rule.
Yeah, so there are at least two conditions there, that's as pointed out by Rin. One is that it must be in his personal capacity, and secondly, there must be consent. The judge must consent to the designation. And of course, I think Monique had raised a question yesterday during the drop-in session about the other requirement, that the designation of the consenting judge must be such as to not interfere with the independence of the judiciary or taint the reputation of the judiciary, because it might be forced to act according to the dictates of the executive. So even if a judge may, under the persona designata rule, may be acting in his personal capacity with his consent in order to perform non-judicial functions, the other requirement in the case of Grollo versus Palmer is that the judge must be acting independently and cannot act as a tool or at the behest of the executive, because in that case that will bring into disrepute the independence of the judiciary. Okay, so we have two rules. We have the Boilermakers case, we have the persona designata rule. So we've identified the legal issue, we've stated the rules. Can somebody attempt to apply the legal rules to the facts? Any volunteer?
Isn't it a judicial, isn't issuing a search warrant, isn't that a judicial act? Isn't that a normal thing that judges do?
Very good question. So is the issuance of a search warrant a judicial act?
TV shows suggest it is.
Yes, it is in Australia.
Well, we have to make sure that we're watching an Australian show, Angelina, and not a US show, because the US constitutional law is different from Australian constitutional law.
Yes, it is allowed in Australia.
Okay, so, but Angelina correctly asked that question. Isn't the act of issuing a search warrant a judicial act instead of being a non-judicial act? Meaning, does the issuance of a search warrant involve the exercise of a judicial power or a non-judicial power? Because if, as Angelina queried, if the issuance of a search warrant is a judicial power, involves the exercise of a judicial power, then we can simply argue that there is no violation of the Constitution, because the act of the judge in issuing a search warrant is in conformity or consistent with his role as a judge, which is to exercise judicial power. So that's an altogether different way of looking at the facts.
Hi, Manjo, it's Kim.
Kim, yes.
How are you?
Very good, thanks.
I'm just wondering then, saying that, for the issue of understate warrants, for a search warrant to be authorised for the police to go in and do, whatever they're searching for, even a magistrate, someone that has basically non-judicial powers, can actually authorise that warrant in even extreme cases. So the issue of a warrant, in my mind, would be based on non-judicial powers. However, if it was to go to a magistrate, obviously, perhaps they could then still be maybe exercising judicial powers, but not necessarily being non-judicial powers. If you understand where I'm getting at?
Yeah, but I kind of heard you use the word state. I'm not sure if I missed that. Were you talking about the state magistrate or a federal judge? Because it used to be that we had federal magistrates, which has now been changed into the Federal Circuit Court. Were you referring?
Yeah, you're right. I probably did say state, but I was probably looking at the Commonwealth.
Okay, yeah.
In the back of my mind, where they could actually bring in non-judicial judges or people that exercise non-judicial powers.
Non-judicial, okay.
So
yeah, the question about state judges issuing a search warrant, we're going to look at that in question 2. So we're going to go back to that issue in a short while. But for now, we're looking at whether or not the act of issuing a search warrant involves the exercise of judicial or non-judicial power. So that should be the other legal issue. So there are two legal issues. One, does the issuance of a search warrant involve the exercise of a judicial power? And two, assuming that it does involve the issuance of the exercise of a non-judicial power, does that exercise then violate the separation of powers as clearly articulated in the case of the Boilermakers case? Now, so let's begin with that first question. I think that is the more basic question. And who was that who raised that question? That's very good. Somebody raised that first question. Was it Angelina, I think? So the basic question we really have is, does the issuance of a search warrant, and we're talking of a federal judge, does the issuance of a search warrant by the federal judge involve the exercise of a judicial power or a non-judicial power? Let's answer that first. Monique said something here that there is no matter. What does that mean, Monique? Can you elaborate on that?
I was getting at that if a judge is issuing a warrant, it's not actually a matter that's been brought before the courts, such as an individual versus a state or an individual versus another individual. That's kind of what I meant.
That's right. So what we need to remember is that, as pointed out by the High Court in Haddad Parker versus Moorhead, judicial power is exercised when there is a matter. Now, what we need to remember is that judicial Chapter 3 courts can only entertain actions involving a matter. So if you look at Section 75, for example, it provides that the High Court has original jurisdiction in these matters. So there is a distinct meaning of matter as defined in Haddad Parker versus Moorhead. And the High Court was clear that there is a matter only when there is an actual controversy between subjects, meaning between citizens of a state or residents of a state, or between the state and its subject, involving rights, liabilities, or obligations, or interests, or legitimate expectations. So there has to be an actual controversy between subjects. So the question is there an actual controversy here between the state and its subjects? Or is this actually something that is at the behest of the federal police? So Leonie says, no, yeah, who was that?
I would say it's at the behest of the federal police.
So there is actually no actual controversy. So
yeah, so the other party, the guy that got searched, he didn't know that there was anything going on prior to his house being searched. So there couldn't have been a controversy because a controversy has to be between two parties.
That's right. So in fact, this is at the behest of the instigation of the federal police. So there is no actual controversy. There isn't a controversy yet. So this is a classic instance where there is the exercise of non-judicial power because there is no matter. So we've answered that basic question. There is obviously no matter that is involved. So therefore, the judge is exercising a non-judicial power. Given that the judge is exercising non-judicial power, does it then mean that this is contrary to the Boilermakers case or the separation of powers? And according to Leonie, it is valid. Leonie, are you able to expound on that? Why would that be valid if it appears to go against the Boilermakers case? Because the judge is exercising non-judicial powers. Oh, the mic is not working. Okay, that's all right. Anyone else?
Zignata?
Monique, okay, yes. So Monique, can you explain that for us?
Okay, so it's allowable if the judge is exercising the non-judicial power separate to that of the court, I guess not in line with his duties with the court, and if he consents to it,
yes,
and if it's not incompatible with his duties as a judge of the federal court.
Very good. So there is an exception to the Boilermakers case, as pointed out clearly by Monique, and that is according to the persona designated doctrine, as espoused, for example, in Grollo versus Palmer or Hilton versus Wells, it is permissible for a Chapter 3 judge to exercise non-judicial powers for as long as the designation is in his or her personal capacity and it is with his or her consent, and that the exercise of those non-judicial functions is compatible with the exercise of his federal duties as a Chapter 3 judge. So we therefore make the assumption that the vesting of non-judicial powers is not on the Chapter 3 court itself, but on individual judges of the federal court who accept the designation, meaning it is with their consent. So the answer is the act is constitutional following the persona designator rule. Very good. Questions before we move on? None. Okay, thank you. Question 2, can we have a volunteer?
I'll read.
To read it. Yes, Sarah.
Alson Magpie was arrested after images showing bestiality were found in his computer that was seized by the police. His computer had been seized and searched on the basis of a search warrant issued by the Judge of the State Supreme Court of New South Wales under the New Security Measures Act of New South Wales. He challenged the constitutionality of the Act, arguing that in issuing the search warrant without giving him a right to a hearing, the judge breached the rules of natural justice and exercised a non-judicial power that was prescribed in the Boilermakers Rule on the constitutionality of the Act.
Okay, thank you, Sarah. I just wanted to know, okay. Briefly, can we just go back to the rule of natural justice here, because I think that's the third issue. Did the judge in issuing the search warrant breach the rules of natural justice? Can we just go back to that? Because I think I missed that, and then we'll go back to question 2. I missed that particular legal issue there. Did the judge, so we need to remember that judges in exercising judicial power have to follow the rules of natural justice. In other words, there is a requirement that judges must provide fair hearing or an opportunity for the parties to be heard. So the question here is, was there a breach of natural justice when the search warrant was issued without notice to Jim Freeman, or the computer was seized without notice to Jim Freeman? Was there a breach of the rules of natural justice?
No, the judge wasn't exercising judicial powers.
Very good. So that's right. So because the judge wasn't exercising non-judicial powers, there was no requirement that the judge had to observe the rules of natural justice. The rules of natural justice need only be observed according to the case of Kiowa versus West if the statute expressly provides for the requirements of the rules of natural justice to be observed, or if it can be implied from the statute that there should be an observance of the rules of natural justice. It is only when there has been a right that has clearly been breached that it can be said that the rules of natural justice should be observed. In this particular case, clearly the law has authorized that the rules of natural justice not be observed because it permitted a judge to issue the warrant without providing notice to Jim Freeman or to whoever's documents or properties would be seized. So the law itself was very clear that there was going to be no adherence to the rules of natural justice. So that was the third legal issue. First legal issue was whether or not this involved a matter, because that leads to the question of whether or not the powers that the law vested in the judge involved the exercise of judicial powers. And the second question was, assuming that what was involved was the exercise of non-judicial powers, whether or not then that violated the doctrine of separation of powers in Australia. And thirdly, the other question was, in exercising non-judicial power, did the judge breach the rules of natural justice? So those were the three legal issues. Okay, so going back to, from Leonie, only this.
Menja, can I just stop you there for a moment to ask a question, please?
Go ahead, yes.
As to search warrants in general, though, it would defeat the purpose if they had to give people warning that they're coming to search for something, wouldn't it?
Exactly, that's right. I mean, yeah. That's a logical argument. That is a logical argument. Okay, but again, it boils down to the question of whether or not a person actually has a right not to have certain documents seized. And there is a common law right against, let's say, unreasonable searches and seizures. There is a common law right that is recognized by the courts. But because it is a common law right recognized by the courts, it is subject to being displaced by a statute that is passed by the parliament, whether or not the statute provides it expressly or impliedly. So any common law right is always subject to it being displaced or overridden by the parliament in a law that it passes. Okay, so now let's go back to question 2. What is the legal issue here?
Same as the last one, except it's at state level.
Okay, so how would you state that?
Well, I guess to take up Jason's point before, separation of powers doesn't really come into it unless they're trying something from a federal perspective.
Okay. So can you try? Can Rain or anyone else attempt to identify or state for us what the legal issue might be? Wait, I just noticed that I had my shirt wrong. So, did anyone notice that until I did?
We're just too polite. We didn't want to say anything, Manjo.
I'm getting old, so just ignore that. It's a new way of wearing a shirt. Okay, I'm gonna try to correct it in a short while. I'm gonna go off video. Okay, so can somebody try to state for us what the legal issue is for discussion question 2?
Yeah, basically, did the state have the power to pass legislation allowing a search warrant to be issued by a judge of the State Supreme Court of New South Wales?
Okay. Can you say that again, Rid?
Okay. Did the New South Wales Parliament have the right to pass a law or act allowing the State Supreme Court of New South Wales to issue a search warrant?
Okay. The problem. Okay. Thank you. As I said, in the interest of learning, the problem I have with the way that it was formulated is that it just repeats the facts. So it doesn't lead us to identify what the relevant rules might be. So that's kind of the factual question, but what exactly is the legal issue there? What's the legal question? Allowing the State Supreme Court to issue a search warrant. So that's one way.
State court vests non-judicial power in a state judge.
Who was that?
Sarah.
Sarah, can you repeat what you said, Sarah?
Can this? Oh, sorry, I said the state court, but I meant the state parliament vest non-judicial power on a state judge.
Uh-huh.
Isn't there another problem that the Supreme Court is considered part of the Chapter 3 courts?
Okay, yes. Very, very good, Gordon. I'm going to get back to you in a short while. I was just trying to type what, who said that? Sarah, I think. The part of us non-judicial power on state judges. On state judges. And then Gordon raises the question of, what was the question? What was your point, Gordon?
Aren't the Supreme Courts considered to be part of the Chapter 3 courts? Or are they constituted in the same way as Chapter 3 courts? Or are they just considered to have the same powers as Chapter 3 courts?
Okay, very good. I think Leonie raised the point that isn't integrated in the federal justice system? Are the state judges acting as tools of the executive? Okay, if you don't mind, can I suggest that the, hang on, read it. Yes. Jamie? Yes.
Wouldn't we be getting back to a similar issue to the last question where could this legislation be unconstitutional because of breach of separation of powers?
Okay. So if we simplify it, the question as pointed out by Jamie really is, does the law breach the separation of powers? And why was that? But why was that, Jamie?
Well, yeah, I was thinking it would be to do with the separation of powers again because hang on, I'm just getting back to my train of thought here. I'm just rereading it again, sorry. So he's arguing that it was unconstitutional that they breached the rules of natural justice and exercised non-judicial power. Well, we're talking about powers and state judges. So it's going to come down to what power the state judges are allowed to, what's the word? What power the state judges hold. So it's going to be an issue of separation of powers.
Okay, very good. Can I just go to the chase now, if that's all right, because we're kind of running out of time. So thank you for that point. Can I just suggest that one of the basic legal issue is, does the issuance of a search warrant, and we're talking of the judge of the state Supreme Court, does the issuance of a search warrant involve the exercise of non-judicial powers? Okay, so that to me is that first legal issue, non-judicial powers. And secondly, if so, does that breach the separation of powers? And thirdly, we go back to the question of, is there a breach of the rules of natural justice? Are you happy with those issues? Okay. We're happy with that. And then we'll go back to the question about the Chapter 3 court as well. We will address that in a short while. So let's begin with that first point. Does the issuance of a search warrant involve the exercise of non-judicial powers? From Kim, not clear. Yes, Kim. Which one isn't clear?
Manjo, I'm thinking that based on probably what I asked in the previous question with the states having absolute no separation of powers,
yes.
If a judge was actually to, even on the Supreme Court of that state, they would have the ability to work in a non-judicial capacity,
yes.
and as a federal court, Chapter 3 court administrator. I'm just a little bit unclear then if we're going now to say that if the state parliament has actually gone ahead and said, look, you know, this is fine, this is what we are going to do, we're legislating against this. I don't see that on a state issue that could be challenged unless it goes on to something that actually vests within a discrepancy between the state and the federal law is where I'm sort of sitting.
That's right. But the point there, Kim, is that you are making a conclusion that it cannot be challenged. But before we can say that it cannot be challenged, the basic question we're asking is, in what ways can the law potentially be challenged? And for us to be able to answer that question, which would then allow us to come up with a conclusion, we first need to identify the legal issue. So the basic legal issue really is, does the issuance of a search warrant involve the exercise of non-judicial powers? And I think we can answer that by saying that it involves the exercise of non-judicial powers. We've said that before in the first question.
Correct, I agree with that.
Yeah, so which leads us to the second question. If a state judge is exercising non-judicial powers, does that constitute a breach of the separation of powers? So that's the second legal issue. What is the answer there? Do we follow do we answer it in the form of the persona designated doctrine?
I would suggest yes. Sorry.
Yes, I was trying to answer there. From Leonie Cable. Okay, yes. So can somebody try to answer that second point? Do we adopt the same rules here? So we're now going to the second question. Does that, if the state judge is exercising non-judicial powers, does that constitute a breach of the separation of powers in Australia? So that's the second legal issue.
No,
Answer
there's
that
no
question.
separation of powers recognised in states apart from under the Cable orthodox doctrine, I think, that recognises that the Supreme Courts are part of the federal system, and so that anything that is inconsistent with the exercise of federal power may not be practiced in those courts. But as long as it's not inconsistent with that power, then yes, then there is no breach of separation of powers.
Perfect. So that is the correct answer there. So the rule, in relation to the second legal issue, the answer, we do not cite the persona designated doctrine, because both the Boilermakers case and the persona designated doctrine apply to the vesting of non-judicial power on federal judges or on Chapter 3 court judges. Because this involves the states, the answer should be that following the case of Cable versus Director of Public Prosecutions, the High Court has been very clear in saying that there is no separation of powers in the states, and therefore it is permissible for a state judge to be exercising both judicial and non-judicial powers at the same time. So the proscription in the Boilermakers case that it is impermissible for non-judicial power to be vested in a Chapter 3 court applies only to federal courts or to federal judges. It doesn't apply, the proscription does not apply to the state judiciary, because there is no separation of powers in the states, except to the extent that it would no longer be permissible if the vesting of non-judicial powers on state judges would be impermissible if the state judge becomes an instrumentality or tool or an instrument of either the state executive or the state parliament, because in that case, that would bring into disrepute the state court, which is actually under the autochthonous doctrine, a part of the integrated Australian federal system. Okay, so was that clear? So the answer is, there is no concern about the breach of separation of powers, because the separation of powers doctrine does not apply in the states. And secondly, the only restriction would have been against the vesting of non-judicial powers on state judges would have been if the judges would then become the instrumentality or the instrument or be at the control of the state parliament or the state executive, because then it would bring into disrepute the federal judiciary system, of which the state courts, whilst not being Chapter 3 judges, are actually part of the integrated federal judicial system following the autochthonous doctrine. So going back to that point by Gordon earlier, while state courts are not Chapter 3 courts, so let me repeat, state courts are not Chapter 3 courts. In other words, they have not been created according to Chapter 3 of the Australian Constitution. In fact, state courts typically are creations of the state constitutions or state statutes. Whilst state courts, therefore, are not Chapter 3 courts, they are still part, at least the state Supreme Court is still part of the integrated Australian federal judicial system.
Manjo?
Yes.
Can I ask a quick question?
Go ahead.
When you say that the judges can't be used as tools or instruments for the state, can you give an example of what you mean by that? Do you mean as in the states can't enforce a judge to do something that they don't want to do?
Yes.
So it's only really if the states or the legislation enforce a judge to act for them.
That's right.
Is that right?
That's right. So, for example, what if this particular law, the state law under the New Security Measures Act, it provides as well that when the police or the chief of police or a member of the police of the state of New South Wales makes an application before a judge that a search warrant should be issued, then the judge must, as a matter of course, issue the search warrant. Must, as a matter of course. It must be automatic. And so therefore the judge is not left with any discretion to deny or to go against the directive. That would be unconstitutional, because it breaches it goes against the integrity and independence of the judiciary, primarily because what we need to remember is that the state Supreme Court, whilst it is not a Chapter 3 court, is still part of the integrated federal judicial system in Australia.
Manja, can I ask for a meaning, a definition of autochthonous?
Yeah, so
in the dictionary.
It is a legal term which you will see in Cable versus Director of Public Prosecutions. So that's simply a concept that has been used. So you probably might not find it in the dictionary, but it is a legal concept used by the court.
It is in the dictionary. It kind of means like as it stands, or
Okay.
so it was kind of like the situation that it stood in.
Okay.
My dictionary must be too old then.
Okay. So let's move on. Any questions on this before we move on to question 3? So we're good? Okay. Discussion question 3. Can we have a volunteer to read the question for us?
I will, Manja. Oh, sorry.
Was that Kim? Kim, yeah, go ahead, please.
Yep. So Alex Cornwall challenged a ruling of the Australian Board of Accountants created under the Australian Board of Accountants Act, Commonwealth, which revoked his registration and licence as a chartered accountant in Australia. The Act authorised the members of the ABA to evaluate and review on the ABA's own initiative the competence and ability of chartered accountants registered and licensed under the Act to carry out or perform adequately and properly their functions under the Act. Cornwall argued that the ABA, in exercising federal judicial powers, violated Chapter 3 of the Australian Constitution. Rule on the legal challenge.
Thank you. Thank you, Kim. What are the legal issues here before we rule on the legal challenge? What do you think are the legal issues?
Firstly, are the functions judicial?
Aha, okay. So are the powers exercised by the ABA judicial in nature? Okay. So that will be the first question we will have to answer. Okay. What do you think? And what's the other related question there?
So, Manja,
Yes.
sorry.
Who was that?
Sorry, it's Kim. I was just looking at, and I haven't looked at this question to be honest, but I'm looking at if it would be in the capacity to actually revoke his registration and license in a chartered accountant of Australia. So I'm assuming straight away it's a federal governed body that would actually, like ASX or something like that, would actually be able to do that.
Okay. So that brings us really to that question of whether or not the power of the ABA to revoke the registration and license of a chartered accountant of Australia involves the exercise of judicial power.
Should we go back to chapter 51, section 51 of the Constitution?
Yes. Why is that?
Because I haven't particularly got it in front of me, but the federal court actually has the power to I guess make rules and laws and judgments, because it is basically a part of revenue, in a broader sense, perhaps.
Okay. Well, if this had been a final exam or a question in a final assessment, it would be what you need to determine in the first place is whether or not it is within the power of the Commonwealth Parliament to legislate on this particular subject matter. So, but for the purpose of this activity, which is in week 5, we're not yet examining whether or not the Commonwealth Parliament has the power to legislate on this subject matter. We assume that it does. We would examine that in greater detail, I think, starting in week 7. So for now, we will not examine that as a legal issue. Toward a final assessment, you need to identify that as a legal issue in the first place. But we assume for the moment that the Commonwealth Parliament has the power to legislate on that subject matter, because it does, which you will see later on. So for now, the basic question that we have is, the basic legal issue that we have is, the powers exercised by the ABA, particularly in relation to its power to revoke the registration and license of a chartered accountant of Australia, judicial in nature, or does it involve the exercise of judicial power? Because if it does, potentially there is a breach of the separation of powers if the ABA has not been constituted as a Chapter 3 court.
I would have thought that they were judicial in nature, but I might be understanding judicial powers wrong too.
Okay.
Would it be considered quasi-judicial?
Oh.
Because it's a tribunal, essentially. If it's a board, wouldn't it be seen as a tribunal and therefore a quasi-judicial?
Okay. What is the significance of raising the concept of being a quasi-judicial tribunal? What is the relevance of that in relation to the legal challenge? So if it were a quasi-judicial tribunal, what is the basis for the legal challenge?
Whether or not they've acted in accordance with their their right to exercise that part of the Australian Board of Accountants Act.
I'm just going to mute everyone. Please unmute yourself if you wanted to say something. Who was the last one to have said something?
Me.
Oh, Angelina, because there was so much background noise there. Okay, so the other point raised by Angelina was whether or not this was actually a quasi-judicial tribunal, therefore not a Chapter 3 court. So,
Manjo.
Yes, and John.
I'm just wondering if, I'm taking it back a step, if the Board of Accountants have actually exceeded their statutory power, because it says to evaluate and review. It doesn't say to take any actions, and usually evaluate and review means to make recommendations to a tribunal or something.
Oh, okay. Yeah. Okay. You're right on that point, but that's probably an administrative law issue. You're right. If it were an administrative law issue, we could raise that, whether it was ultra vires. But for the purpose of the constitutional law aspect of this legal question, what we're really trying to determine is whether or not the ABA is exercising federal judicial powers. That's the basic question. So in revoking, given its power to revoke the registration or license of a chartered accountant, is the ABA exercising federal judicial power? Because if it is, the next question is, has it been constituted as a Chapter 3 court?
Isn't it only that the decision can be appealed?
What was that?
Does it depend on whether the revocation of his registration can be appealed to a Chapter 3 court?
Oh.
If it can, then it is a quasi-judicial.
Why is that relevant?
Well, there's no finality in the decision.
Okay.
I just kind of think that there's no real matter. They're reviewing his registration.
Okay.
It's only a matter once they take his license away, then he's disputing that decision. Now there's a matter. There wasn't a matter before.
Very good. So actually what Sarah is pointing out is whether or not the legal issue of whether or not the ABA is exercising judicial powers really raises the question of whether or not the revocation of the registration and license involves a matter That is the basic question there. And there are two aspects to the notion of power, of matter, as pointed out by Sarah, again, according to Haddad Parker versus Moorhead. One is that there is an actual controversy between subjects of a state or between the state and its subjects involving rights, liberties, or freedoms or obligations. And secondly, that the tribunal, which is making an adjudication, is actually able to make a binding, conclusive, and final determination on the controversy. So that is the second aspect of what will constitute a matter, which then brings into the question of whether or not what has been exercised is judicial power. So those are the two components of the definition of matter. So going back to the first, is there an actual controversy?
No.
The answer is no, because it clearly says here it is on ABA's own initiative. So there is no actual controversy. And which leads us to that second question, which is actually moot then, whether or not the ABA is able to make a binding and a final and conclusive binding decision. Because,
No, it can't.
because the fact that what is involved here is actually the act of ABA doing something on its own initiative means that this that the ABA is not undertaking judicial powers, or is not exercising judicial powers. Okay, and because the ABA is not exercising judicial powers, it cannot run afoul of the prohibition against the vesting of non-judicial power to Chapter 3 courts, because the ABA has not been constituted as a Chapter 3 court. There are also indications that this is not meant to be a part of the federal judicial system, because the standards used in the way that the ABA makes a determination uses the concept of adequately and properly. Those are not really legal standards. They are more of being administrative standards, according, for example, to policy prescriptions. And that goes to the point about this being a quasi-judicial tribunal. So this appears to be a quasi-judicial tribunal and not constituted as a Chapter 3 court. And therefore, there is no breach of the separation of powers. Okay, questions there? So the ABA, because Sharon raised the question, is the ABA a federal court? So the answer is that it is not a Chapter 3 court, mainly because it hasn't been constituted according to Chapter 3 of the Australian Commonwealth Constitution. We have a final question, but it's 7 o'clock.
Manjo, I was just wondering if you could give a bit more clarification on what is actually considered a controversy, please. I'm still a bit confused about that side of it. I think that's where I'm getting mixed up.
Okay. So there would be an actual controversy. So let's look at, because a lot of the cases involve contracts, for example. There is an actual controversy when one party, for example, alleges that there has been a breach of his rights under the contract. So therefore, he goes to court in order for the breach of his rights to be remedied by a court. There's an actual controversy there. There can also be an actual controversy when there is a dispute, for example, about who has rights over a child, or concerning who has custody over the children. There is a controversy because that involves a determination of what the rights of the respective parties are, or what the rights of the children might be. There is again an actual controversy there. There's also an actual controversy when somebody is said to have violated a law, and therefore there's the legal question of whether or not that person may be subject to punishment. You can see the actual controversy there, because there's an allegation that there has been an infringement of the law and a violation of certain legal obligations on the part of a person.
Yeah, thanks. I got it now. Thank you.
You're welcome. There is a point raised here by Ernest. Does it mean that the ABA is allowed to go scot-free when it creates a controversy which could actually lead to revocation of someone's certificate of practice? Okay. there is a potential controversy that will happen once the ABA makes a decision. So when the ABA, for example, on its own initiative revokes the registration and license of an individual, there is no controversy yet. Because did somebody want to say something?
Yeah, Manjo, I was just going to say, is it that it becomes a controversy once an action from the administration is disputed?
That's right.
But prior to that action, there is no controversy.
Exactly, that's correct. So prior to the ABA action in revoking the license, there is still no controversy. There is no actual controversy because the ABA is doing it on its own initiative. So in that case, the ABA is not exercising judicial power. But once the ABA actually revokes the license, there is an actual controversy between Alex Cornwall, whose license was removed or was revoked, and the ABA. So Alex Cornwall can now potentially file an action against the ABA. There is an actual controversy there.
Is this, Manjo, where he could apply for a writ of mandamus to have that that revocation reversed?
The appropriate remedy wouldn't be a writ of mandamus, and I'm not sure if you should go into this because the writ of mandamus assumes that there is a clearly recognizable right on the part of the applicant. And that is the basic question, because it would appear in this case that the right of Alex Cornwall is not clear because it has in fact been revoked. So the possible remedy could be an injunction. But the broader question really is, assuming that the rights of Alex have been, as a licensed chartered accountant, has been revoked by the ABA, so that leads to an actual controversy, what then are the remedies? So the body to which Alex Cornwall can bring that matter, because there would then be an actual controversy in relation to his right to a license, that brings to the question of whether should he go to the courts or should he go to an administrative tribunal. Okay, now potentially, if the Administrative Appeals Tribunal, for example, if the Australian Board of Accountants Act Commonwealth provides that an application for review can be lodged with the Administrative Appeals Tribunal, then there is potential recourse for merits review on a question of merits or on a question of the facts. But if there is a legal question that is involved, then what would be involved is would be judicial review. And in that case, the body that would then examine the actual controversy has to be a Chapter 3 court.
And because they're referring to a Commonwealth Act, doesn't that make it a matter of law?
Not exactly, because the basic question is, what was if a person is seeking to dispute or seeking a review of the decision, what is the basis for questioning the decision? Is it on the basis of the facts that were cited by the original decision maker or by the ABA in arriving at the decision, or is it on the basis of question of law? Because if it is a question of on the basis of the merits or on the question of the factual correctness or the way that the ABA may have evaluated the facts, that cannot be evaluated by the courts because the concept of judicial review is limited only to questions of law. And it does not examine factual questions because the notion of the power of judicial review is limited towards a supervisory role on the part of the courts to ensure that executive tribunals do so in accordance with the rule of law and in accordance with the law itself. So therefore, it is impermissible generally, and I don't want to expound on that because we're going into administrative law. But generally, it is impermissible in a judicial review. It is not possible for an applicant to raise the question of whether or not the decision makers, such as the ABA, correctly made a determination on the basis of the facts. So, for example, when the ABA revoked the registration of, let's say, Alex, when the ABA evaluated the facts, was were its findings correct? That is a factual question, which cannot be the basis for a judicial review. It can potentially be the basis for an administrative review by the AAT. But in a judicial review, it can only be on the basis of a legal question.
And one more question, sorry. If Alex determined or felt like the ABA acted with justice, like unfairness, then does that qualify as a question of law, considering the law states that a cohesive judicial tribunal must act with judicial fairness?
I'm not sure if I should be answering that question because that's administrative law, but I can answer it. But let me point out that my answer is not meant to be part of constitutional law. This is really kind of relating to administrative law, which I think some of you would be at this point interested in knowing anyway, just to get a full answer to the questions that are raised. So, so what Angelina was saying was the question of unfairness. So, if you look at the Administrative Decisions Judicial Review Act of 1977 Commonwealth, one of the grounds for judicial review with the Federal Court of Australia is that there has been a breach of the rules of natural justice. And when you speak of the breach of the rules of natural justice, that also involves the question of fairness. But related to that is really the fact that the Administrative Appeals Tribunal can actually examine whether or not the ABA was acting, or the original decision maker was acting fairly. Because when it examines the question of whether it was acting fairly, it will actually be looking at the facts. Now, I don't want to...
That's answered my question.
But I don't want to go into detail on that because that's administrative law and can get confusing if I'm trying to answer it in just a few minutes. And as Kim pointed out, she's getting confused. So
sorry.
Yeah, I was just trying to answer, but that was really cool. So questions about evidence, if it's a question about was the evidence sufficient? Okay, that is actually a question about merits. So you cannot, assuming that the ABA made a decision that revoked the license of Alex Cornwell, so that leads to an actual controversy, if the next question then had been, was there sufficient evidence for the ABA to have arrived at the decision, that actually is a factual question, which can go before the court. But as I said, that is an administrative law question and is not a constitutional law question. I'm only attempting to answer the question because it has been raised, but that is not part of constitutional law. It is not a constitutional law question. As far as constitutional law is concerned, we only ask whether or not the court, for example, is trying to look at the legality of an action by, for example, an executive decision maker, or whether it is examining factual matters or the merits of a decision. Because if a court is examining factual matters after a decision has been made by an original executive decision maker, then there is a problem in relation to the separation of powers, because it is not for the courts to act as a supervisor over the executive on whether or not the executive is correctly making an executive decision. The only question for the court is not whether or not the decision of the executive is correct, but only whether or not the decision of the executive is legal or whether or not it is according to law, broadly defined. Because otherwise, if the courts were to examine the factual determinations made by the executive, that would be a breach of the separation of powers, because the courts are not over and above the executive. And the power of the courts only relates to legal questions. Its job is not to determine whether or not the executive made the correct factual decision. Okay? So it's 7:11, and I think I need to go because I have a class in administrative law in 4 minutes.
Sorry, Manju, you've just really confused me. You've just thrown me off the whole track of thought there, but I'll go back and review that. Thank you. I know everyone's got things to
So
go
we
to.
ended up talking about administrative law, and that can get confusing.
Yeah, this
This
is really throwing me off on constitutional law because I'm putting my administrative head on, and I haven't done that for a while. So, yeah, you've just thrown me off track for a little bit, but I'll have a look at this again, and hopefully, I'm going to put some questions too. I think that
that'll be fun.
Can I ask one very quick question, Manjo, before you go, please?
Yeah, Sarah.
Just about the assignment question 2 of the group ones, the rights that Juliet has lost with regards to the vaccination. She hasn't lost pre-existing rights. She's only lost the right to future benefits given that she has now refused to vaccinate. Is that correct or not?
I can't answer that because that goes to the heart of the assessment, even if I wanted to.
Whoops.
How does it go to the heart? I don't...
Yeah, I can't answer that because that's part of the assessment. Something that you can discuss with your classmates. We can talk about a concept, but not the assessment itself, not the assessment questions. Okay. So I guess this is a good time to end it. And I thank you for joining tonight's session. In fact, a lot of people have dropped out. Okay, so I think it's the time to go. I've got a class in 3 minutes. So thank you everyone for joining and for contributing and engaging a lot in tonight's session. See you soon.
Good night.
Good night. Bye.